I rise first to declare an interest as a barrister who occasionally practices in employment law, and secondly, to note that during the committee stage of this bill on the 18th of June, Hansard recalls that I described this bill as a complete Horlicks, totally bizarre, and absolutely beyond belief. My Lords, I am amazed at my moderation. Nothing I have heard since addresses my concerns. Let us remember that this provision, as ably outlined by the noble Lord, Lord Carter of Haslemere, with whose clause stand part amendment I entirely agree, as he ably outlined, this measure allows the Secretary of State to bring any complaint in an employment tribunal without the consent of the complainant. Have these people ever been to an employment tribunal, I ask you, my Lords? This is absurd. Is it proposed that in the event that the claimant has the temerity to disagree with the Secretary of State's assessment that they have a valid claim, is it proposed to witness summons the claimant on pain of arrest if they don't come and give evidence in support of their claim? And if they have the temerity when there, while giving evidence, to give evidence against their claim, brought by the Secretary of State on their behalf unwillingly, will they apply to the judge to treat their witness as hostile, thus permitting them to cross-examine them on the basis that they really were badly treated by their employer? My Lords, this is palpable nonsense, and I really cannot stand part of this bill. I also would like to draw the House's attention to the fact, as raised by the noble Lord, Lord Carter of Haslemere, that this is an exercise of discretion on the wording of the provision in the bill, so it's therefore capable of judicial review. So there can be a judicial review of the decision both to bring proceedings on the part of the unwilling claimant and a judicial review to decide not to bring proceedings. This is going to be marvellous for those of us who are both at the employment bar and at the public law bar. There will be endless litigation and all at public expense on every side. This is absurd, and I invite the House to remove this clause from the bill as swiftly as possible.
I cannot match the tones of the noble Lord Murray. But I do agree with the thrust of his remarks. Noble Lords often oppose clauses in government bills. Sometimes noble Lords are alarmed by such clauses, but very occasionally it is appropriate to say that a clause in a government bill is simply bonkers. Technical term, but appropriate in this context. That is the appropriate term in respect of a proposal that the Secretary of State should be given power to bring proceedings in an employment tribunal in place of the worker who has the employment right, where it appears to the Secretary of State that the worker is not going to bring proceedings. This is a quite astonishing provision for all the reasons given by Lord Carter, Baroness Neville Rolfe, and Lord Murray, in particular because the bill does not require the Secretary of State even to consult the worker whose rights are to be pursued by the Secretary of State, far less to obtain their consent. Of course, the worker may have good reason not to want to bring proceedings. Not everyone wishes to spend more time with their lawyers. Not everyone wishes to have the finer details of their conduct picked over in public by lawyers for the employer and to be the subject of a public judgment. I declare my interest as a practicing barrister occasionally in employment law cases, and I spend much of my time advising clients in all areas of the law that litigation is not necessarily the answer to their problem. The idea that the Secretary of State should decide whether to bring proceedings and not the worker themselves could only appeal to those who believe in a state which is ever expanding to take more and more responsibility for areas of life. So what is the mischief which this provision is designed to address? The Minister very clearly set that out at committee stage, column 2052 on the 18th of June. She said, can I quote, "Vulnerable workers, especially migrant workers, are reluctant or unable to bring their case to the tribunal to enforce their employment rights," unquote. Can I first ask the Minister, where is the research which supports this assertion, especially when trade unions do provide legal advice and often representation to their members? And can I suggest to the noble lady that by far the most substantial reason why vulnerable workers are unwilling to bring proceedings to vindicate their rights in an employment tribunal is the absence of money. It's the absence of legal aid. There is no legal aid for an employment claim unless it alleges discrimination, and even then the legal aid does not cover representation in the employment tribunal. That's why people are reluctant to bring claims. Clause 114 will certainly assist in that respect, as Lord Carter pointed out. But the idea that money should be spent by the Secretary of State bringing proceedings in his or her name is a remarkably inefficient and unsatisfactory way to proceed. There are three other objections to Clause 113, which I want very briefly to mention. The first is that this clause is, so far as I am aware, unique in our legal system. I can think of no other context in which the government has power to bring proceedings to vindicate the legal rights of an individual who has chosen not to sue. No other context in this country, at least. The second point is that if the Secretary of State is to have such a power in employment law, why not in landlord and tenant law? Why not in proceedings for debt? Why not in family law? There are many areas of the law where vulnerable individuals have rights which they do not enforce. And the final point which I want to mention, I don't think has been mentioned yet, concerns the financial cost of implementing Clause 113. Can the Minister tell the House, what is this going to cost? And this is important because there are so many urgent needs for funding in our legal system. The government cannot afford to pay for more sitting days in the Crown Court. And so rape trials are being listed for 2029. This is outrageous. And because there is no money available, courts up and down the country are in a state of disrepair, with some judges conducting hearings in courtrooms where the roofs are leaking rainwater into buckets. The legal aid system has been drastically reduced in scope. Legal aid lawyers are not properly paid. And the government has not yet brought forward the much-needed Hillsborough legislation to protect victims of major tragic incidents, because the Lord Chancellor has made clear that she does not have the funding to pay for lawyers to represent those victims at inquiries. It is quite simply a disgrace that instead of meeting some of these urgent financial needs of the legal system, money is to be spent on this ill-conceived, unprecedented and inefficient scheme for the Secretary of State to become a professional litigant on behalf of workers. I very much hope that Lord Carter will divide the House. He will certainly have my support.
Thank you, noble lady. My Lords, there are several styles of advocacy, and we've had a good experience of some of them this evening, but in every way those who have spoken before me have been devastating in their unpicking of the ludicrous nature of the clause that the noble Lord Carter of Haslemere is seeking to have removed from the bill. And I cannot improve on the gentle forensic approach that he took to the ludicrous nature of this particular clause. The legal ramifications, its workability, and its policy defects are just plain on the face of the bill. And I'm amazed that any sentient minister, I'm amazed that any sentient member of any legislature could come forward with a proposal in the form of Clause 113. It is manifestly absurd. And as the noble Lord Panic again very thoroughly pointed out, the implications of this particular clause are so obvious for us all to see that it's even surprising that the government has the nerve to come forward with it and to maintain its support for it. One thing that this clause brought me in mind of was, and now I'm going to get into my anecdotage. Yes, I too am a member of the bar, but I confess that I have never once, at least not knowingly, been in an employment tribunal. But what I do remember is about 40 years ago, I was asked by some visiting Chinese judges to this country to explain to them the English law of defamation, which I did. And after I'd given what I thought was a pretty uncontroversial explanation of the law of defamation in this country, one of the Chinese judges said to me, just hang on a minute, do you mean to say that an individual has a reputation which can be injured, and if injured, he can receive compensation for that injury in the courts of England and Wales? I said, yes, they can. It's fine, isn't it? And they said, but no, surely no individual citizen, if there is such a thing, has a private reputation. It is subsumed in the interests of the state. It is subsumed in the interests of the Communist Party of China. And so the possibility of bringing a libel action as an individual was just foreign to him and quite puzzling. So if your entire personality is a creature of the state, well then I suppose you would support Clause 113, because it is the state which takes over, as the noble Lord said, your personal autonomy, and makes all the decisions about whether to sue or not to sue, whether to bring proceedings or not to bring proceedings, whether to give evidence, as my noble friend Lord Murray so graphically explained a moment ago. And why should we, on behalf of the people of this country, tolerate what is little more than an Orwellian intervention in the private lives of the citizen? I can't believe the government has any decent excuse or explanation for this, to use the technical term that my good friend, the noble Lord Panic, introduced into this debate a moment ago, this bonkers piece of legislation. The bill has got plenty wrong with it as it is. If we are not to laugh at the government, if we are not to ridicule the government, if we are not to lose such little respect as many of us still have for the government, I do really suggest they remove this ludicrous clause.
My Lord, the devastating interventions that we've heard so far, I hope will make